Hello everyone, my name is Emmanuel Opande, and today I'll be presenting an overview of the legal and ethical implications surrounding the lawsuit filed by content moderators in Kenya against Meta and its local outsourcing partner Sama. So this case brings to light important issues at the intersection of technology, mental health, workplace safety and labor rights across different jurisdictions, namely Kenya, Canada and the US. So just a brief overview of the case. In March 2023, 187 former content moderators in Kenya filed a lawsuit against Meta and Sama. These moderators were regularly exposed to extremely disturbing content which included murders and child abuse, leading to severe mental health issues such as PTSD. They alleged that inadequate psychological support, unfair labor practices, and retaliation were met when they attempted to organize or speak up. So this case is not only about the compensation, but also about accountability in the digital labor systems. So moving on to the grounds of the lawsuit. So the lawsuit rests on 5 main grounds, one of them being unfair labor practices, where we saw that the moderators were dismissed or they retaliated against for organizing or trying to organize the unions. The other ground is the intentional infliction of psychological harm, where the nature of the job was inherently damaging without adequate safeguards. The other was employment discrimination, which is a lack of equal protection or benefits compared to the employees. So this is in relation to one of the reports from the Guardian, which claimed, where one of the content moderators claimed that their other counterparts in the US received 8 times their salary. The other ground was the curtailing the right of justice, where Meta was seen to use legal loopholes to avoid responsibility. This included claims that the Kenyan courts were not within the jurisdiction to judge the case since the company itself was not based in Kenya. The other ground was unlawful redundancy, where had abrupt job terminations without due process was witnessed in the country. So this isn't the first time that moderators have sued major tech companies. In the US, there was the Selena Scholar versus Facebook and Pro Unlimited lawsuit in 2018, which is a landmark case where the moderators alleged PTSD due to the graphic content exposure. Another case is the Jane Doe versus YouTube Incorporation lawsuit in 2020, which raised similar claims. Then there's the Reese Young versus ByteDance Incorporation, which targeted TikTok's parent company, in this case ByteDance, for psychological harm. So from these cases we can see we can see there's a growing pattern of legal action demanding corporate accountability for mental health impacts. I have attached the live links to the references on this as well. So over the years there have been different lawsuits, as addressed earlier, against big tech companies. So here is the timeline of the said cases. So whistleblowers in the mid 2010s raised awareness, one of them being in September 2018, where we had the Scholar versus Facebook, which marked the first major legal action against Meta. Then on the same year, Selena Scholar and others filed a class action lawsuit against Meta under the same claims of psychological trauma faced from being exposed to graphic content. So further lawsuits followed against YouTube and TikTok. By 2022, the Kenyan case became the first major legal challenge of its kind in Africa. So from this we can see that each case has built momentum toward recognizing psychological harm in content moderation as a legitimate labor rights issue. So let's look at how the Canadian law addresses workplace psychological harm. So the first is the Canadian Labor Code under section 122.1, which requires the employers to prevent the accidents and psychological injuries in the workplace. This is in relation to the claims made by the Kenyan content moderators who allegedly accused some source of not providing the adequate working conditions while they were working as content moderators in Nairobi. Another similar applicable law is under section 124, where every employer is required to ensure that the health and safety of every employee is maintained at the workplace. So this follows claims from the reports from media outlets like The Guardian, where content moderators alleged that the environmental conditions at the workplace were not suitable for working. Some describe the environment with having bright lights, some say there were chilly air conditioning, uncomfortable chairs, all while under strict supervision from the managers. So under the Canadian Human Rights Act, under section 3 and 7, which prohibits discrimination, including on disability grounds, which can include psychological harm. The live link for that as well has been attached on the slide. Well, when you look up the definition of disability on Google, a disability is defined as a physical, mental, intellectual, or sensory impairment that makes it harder for a person to participate in society on an equal basis with others, especially when confronted with various societal barriers. Most of the content from various reports, most of the content moderators claimed of developing insomnia, which is from PTSD due to the graphic images, and some even developed phobias such as trypophobia, which is the fear of small patterns, which was mostly viewed in most of the graphic contents. So this qualifies as a discrimination, since the PTSD claims by the content moderators can be categorized as a disability. So this forms a legal ground on the same. Under Section 7 of the same Canadian Human Rights Act, it is a discriminatory practice to directly or indirectly refuse to employ or continue to employ an individual. So this is in context to the allegations in the Kenyan Content Moderators versus Meta and Summersource case, where we found that some of its employees were laid off because of trying to form unions that were meant to protest against unfair compensation claims and poor working conditions. So this was bad to the extent that Meta even blacklisted some of its former employees from their job application systems so as to prevent them from applying to jobs that have been advertised by the company in the future. So in the context of the Canadian law, this applies as grounds for discrimination. So moving on to the next law, under the Provincial Occupational Health and Safety Act legislation for Ontario, under Section 25, which requires the employers to provide adequate health information in medical emergencies. So this is in context to the grounds of content moderators' claims of receiving poor psychiatric services from practitioners who are unqualified. This then forms eligible legal grounds under the Ontario Occupational Health and Safety Act, where employees are required or should receive medical services from qualified medical practitioners who are competent for the job. So in the US, relevant laws may include the Occupational Safety and Health Act, which requires the employers to provide a workplace which is free from recognized hazards, including psychological ones. This is in context on the previous claims discussed on the content moderators in Nairobi who are working under poor conditions such as chilly air conditioning, which could potentially lead to health complications. This can form a legal ground in connection to the duties of employers under the US Occupational Safety and Health Act. The link to the same has been attached. Another American law that can be applicable to the lawsuit is the Americans with Disabilities Act, which protects the employees from unlawful redundancy and requires reasonable employee compensation on the same. This is in relation to the psychological trauma which was inflicted on the content moderators in Nairobi. So moving on to the state jurisdiction, using California as an example, the California Labor Code section 3208.3 recognizes compensable psychiatric injuries if work related. So this is in response to the claims made that due to constant exposure to graphic materials, the content moderators develop psychological trauma and were not compensated adequately for the same. So when we compare the Canadian and the US laws, we can distinguish them in different angles. We have the scope, the different enforcement mechanisms used, the approaches, that is the federal versus state for the US and the province for Canada, and the coverage of the laws addressed. So when we look at the scope, Canada's framework explicitly names psychological injury, making it easier to build legal claims, while in the US, in as much as the protection exists, it requires framing the issue as a hazard or a disability, which can be harder to prove since it relies more on the general duty clauses and does not exactly pinpoint psychological trauma as a disability. Moving on to the enforcement and mechanisms, Canada has more centralized proactive enforcement. This can be seen from the labor inspections, the human rights tribunals, workplace safety and insurance board. In this case, I used Ontario as an example, while in the US, it is more decentralized and relies heavily on the worker initiating the process. Looking at the approach, we can say this is a key difference because when you see in Canada, the employer is expected to prevent harm, while in the US, the frameworks generally respond after the harm has already occurred. Canada has federal and provincial layers with standardized protections, while if we compare the same to the US, the approach to the law is a bit fragmented across the different states. Yeah, so for the coverage, Canada has clear inclusion of psychological harm across the different legal frameworks, whereas the US tends to treat it case by case. So both countries recognize psychological harm but differ in legal clarity and the enforcement strength. Yeah, from this, can maybe summarize them into main key differences. So we can see that Canada's legal framework is more structured, proactive, and consistent nationwide, while the US framework is more fragmented and reactive, making it harder for employees to prove psychological harm and receive compensations. Ethically, Canada incorporates dignity and well being more explicitly, while the US is more compliance focused. Well, despite the differences in both countries, both acknowledge psychological harm as a legitimate workplace issue. In both, the workers are allowed to seek remedies or compensations for unsafe work environments. They both hold employers legally accountable for failing to ensure safety. So this means that global companies like Meta in this scenario can face potential legal exposure in both jurisdictions. This slide highlights the ethical dimension in context to the legal applications in both countries. From this, we have seen that the Canada laws are stronger, proactive, and ethical. For the US laws, it may be harder to prove psychological harm. Another ethical component is that we have seen from this is that Canada incorporates ethical concerns, which is the employment, dignity, well-being, alongside financial remedies, while the US focuses more on compliance and financial remedies. Well, legal remedies are important, but ethics go further, addressing employee dignity, trauma, and long-term support. Ethical obligations push companies to go beyond compliance and adopt duty of care models that prioritize mental health and employee welfare, and not just focusing on the profits streaming into the company. Legal action is one path, but companies can also adapt non-legal solutions to prevent harm. Some include corporate mental health programs, continuous counseling and trauma-informed training, task rotation to reduce exposure to disturbing content, and peer support networks and assistant programs. So these measures can mitigate harm, build a healthier culture, and help prevent some of the lengthy lawsuits. In this case, you can see that the Kenya Moderators versus Meta lawsuit took almost three to 4 years. This case is a reminder that the digital economy depends on human labor, often invisible, and protecting these workers legally and ethically is essential for both parties as this ensures that the legal frameworks are respected by both parties. Thank you. I was hired with the promise of a good job, decent pay, and the chance to work for one of the biggest tech companies of the world. What I didn't know was that my daily job was to watch horror, murders, child exploitation, torture, and every kind of violence you can imagine. So at first I thought I could handle it, but after weeks of exposure, I started having nightmares, I became anxious, depressed, and felt detached from life. The support we got was very minimal. One counselor for hundreds of workers. Breaks were short, and if you complained, you risked losing your job. What I believed, what I believe is right, is for companies to treat moderators like human beings, not disposable shields that absorb the worst of the internet. It's wrong that you are paid a fraction of what others doing the same work and overseas. Taking the example of the US, it's wrong that when you spoke up or tried to form a union, you were intimidated, and in my case and others, we were laid off. I'm speaking not just for myself, but for hundreds of moderators who are living with trauma that could have been prevented. We deserve justice, dignity, and recognition. We operate one of the largest social media platforms in the world. Every day, billions of users post content, and content moderation is critical to keeping people safe. It is an incredibly difficult and complex task. We outsource moderation to specialized vendors like Summer so as to ensure local compliance and create jobs in the emerging markets. We provide guidelines, training, and some mental health resources. We recognize that the work is hard, but in the same case, it is essential to protect the billions of meta users. What we believe is right is balancing business responsibilities with operational realities. It's wrong to assume the company can eliminate all psychological risks. The nature of the job itself is inherently distressing. We also have to consider business sustainability, global consistency, and legal boundaries. We are open to improving the conditions, but lawsuits create a perception that we are deliberately harming workers, which isn't the case. We need structured frameworks and shared responsibility, and not just blame one party. We use these platforms every day to connect, share, and stay informed. Most of us don't even realize someone has to see the worst content to keep it away from us. So when we learn that moderators are exposed to horrifying material with little support, we feel disturbed and complicit. It doesn't feel right that big tech companies make billions in profit while the people doing the hardest, most traumatizing work barely earn a living wage. We believe in human dignity and corporate accountability. If a job causes predictable trauma, then companies should provide meaningful protections and fair pay. We are also concerned about our own safety online. If moderation fails because workers are burned out or traumatized, society as a whole is less safe. So protecting moderators is in everyone's interest. In Ontario, we are guided by the Occupational Health and Safety Act and the Canadian Human Rights Act and the Workers' Compensation frameworks that recognize psychological injuries as legitimate workplace harm. From a legal and regulatory standpoint, if such a case arose here, the employer, whether direct or indirect, will have a duty to provide a psychologically safe workplace, conduct regular risk assessments, and offer accommodations and support. We believe that workers' mental health is just as important as their physical safety. It will be wrong to allow large corporations to bypass accountability through outsourcing. Our concern is ensuring clear jurisdiction and enforcement in globalized work structures where work happens in one country but decisions are made in another. We aim for a system that protects workers while allowing businesses to operate responsibly. From the victim's point of view, there's a feeling of trauma, betrayal, moral injury, and a strong sense of justice. So, my belief in this is that psychological harm should be treated as seriously as physical harm. The main concern is that corporations exploit cheap labor in low-income countries without accountability. In the case for the corporation, the feeling is defensive, rationalizing, focused on risk management. So my belief in this is that psychological harm can be mitigated but not fully eliminated. The main concern with this is legal liability, reputational damage, cost of implementing global safety standards. In the case of the society at large, which is the citizens, the main feeling is shock, empathy, and a demand for justice. The belief is corporate responsibility and transparency, which are moral imperatives. The main concern with this is that the digital platforms have a hidden human cost. Then there's an erosion of trust. From this, then leads to an erosion of trust in the big tech companies. From the regulator or the court, in this case, the feelings are neutral, duty bound, focused on precedent and enforcement. The belief is that psychological harm must be legally recognized and compensated. The main concern is cross-border enforcement, corporate jurisdiction, and the setting is the legal precedent. So between the four roles, with the clash that we find in the roles include the victims demand justice and acknowledgement, while the corporations aim to limit liability and control the costs faced by the organization. The society wants ethical standards and transparency upheld, and the regulators, in this case the court, they try to navigate the legal gaps in the globalized economy as a whole. The possible solutions for this include mandatory mental health standards, where the governments uh, should require a minimum psychological protection for high-risk jobs such as content moderation in this context. And the companies as well should align to the legal frameworks globally to reduce jurisdictional loopholes. The second possible pathway is shared accountability, where the tech companies and the contractors should share the responsibility for worker safety and prevent outsourcing as a legal shield. In the case of giving an example, in the case of Meta and Source, where Meta was trying to prolong the lawsuit by transferring the risk to Source. The third solution to this is worker empowerment and representation, where support for unions and the worker councils, which will ensure the workers' voices are heard early, preventing escalation. The final possible solution to this is public transparency, where annual reporting on working conditions in content moderation, which may then lead to an increase in trust between the companies and the users, the public as a whole. The Kenyan moderator's case against Meta and Sama highlights not only the legal failures but also deeper techno-social consequences of the digital platforms that we rely on every day. Behind every social media post, video, or comment, AI systems and human moderators work together to remove the harmful or illegal content. Yet, the very technology that was designed to protect its users, artificial intelligence, facial recognition, and automated moderation, it has also amplified ethical and legal dilemmas, especially around the worker well-being, privacy, and accountability. Modern platforms like Facebook and TikTok depend heavily on AI-powered moderation systems to flag and remove violent or abusive content. These algorithms rely on machine learning and sometimes facial recognition to detect prohibited materials before the registered users see them. However, this AI moderation remains imperfect as it often makes I can say two critical errors. The first is the false negatives, where the violent or exploitative material slips through the algorithm and must be reviewed by human moderators. The second is the false positives, where harmless or artistic content is wrongly removed, raising the issues of freedom of speech and censorship concerns. So these limitations place enormous strains on on humans in the loop. In this case, the moderators who must review what the AI cannot handle. From a legal standpoint, this creates a gray zone of accountability, such as who bears responsibility when the moderators suffer psychological trauma. The parent company that owns the AI, the subcontractor managing the workforce, or the algorithm itself, you can't really tell for sure. Ethically, the technology allows corporations to scale globally while outsourcing the human cost to workers in developing countries like Kenya, where labor is cheap and the regulation is, you could say, weaker compared to the first world countries. So, for the human and organizational consequences, you can say that for the people doing this work, the human cost is devastating. Many moderators report psychological trauma, anxiety, and post traumatic stress disorder from prolonged exposure to graphic material. Organizationally, companies attempt to respond by increasing the automation, replacing human judgment with AI, which often leads to mass layoffs as seen in multiple global moderation centers. But automation introduces new dangers. Algorithms may replicate societal bias, flagging content unfairly based on race, language, or political context in some cases. And this raises ethical questions about fairness, discrimination, and freedom of expression. So, while automation aims to protect human workers, it also deepens the divide between technological progress and human dignity. In the issue of the broader techno-social impact of the same, these consequences, the consequences of these technologies extend beyond the individual workers. At a societal level, content moderation determines what we see, what we believe, and how we interact online. When human moderators are traumatized and when the algorithms silently decide what's acceptable speech, digital platforms shape the moral boundaries of the internet, often without the transparency or oversight. So this creates what scholars call the technosocial paradox, where the technology designed to protect the people can also dehumanize those who maintain it. The Kenyan case illustrates this clearly, where the global corporations benefit from AI moderation, yet the workers are at the periphery pay the psychological price. So, in conclusion, the intersection of technology, law, and ethics demands a new kind of accountability. AI moderation, social platforms, and facial recognition technologies cannot replace moral responsibility. The Kenyan moderator's case reminds us that technological process must include human protection, mental health support, and transparent governance. And without this, the digital world risks building systems that are efficient but unjust at the same time. So, as I reflect on this case, I find myself torn between admiration for technological process and the concern for people it leaves behind. So being raised in with Christian values, I was always taught that every person carries an inherent worth that is justice, fairness, and compassion, and not only are not only optional virtues but moral duties. So those teachings shape how I see this case. When I hear the stories of Kenyan content moderators who suffered trauma while working for Meta and Sama, I don't just see a legal dispute, I see an ethical crisis, and one that tests how deeply we value human dignity in the digital age. So, with how my values shape my judgment, there are some Christian teachings which emphasize the idea that the worker deserves his wages and that whatever you do, the least of this you do unto me. So these values shape my judgment by reminding that profit should never come at the expense of people's well-being. In this case, moderators were paid very little, exposed to disturbing content daily, and reportedly dismissed for organizing for better conditions by trying to form the unions. To me, that violates not only legal principles but also moral ones. It breaches the command to treat others as we wish to be treated. Justice, in my understanding, isn't merely about punishing wrongdoing, it's about restoration, ensuring those harmed are healed and those responsible change their behavior. So, when I view this case, I don't only seek compensation for the workers, I seek repentance and reform within the corporate system, a culture shift that honors both efficiency and empathy. So if I were in the regulator's seat in a jurisdiction like here in Ontario, I would handle the dilemma with both firmness and compassion. Legally, I would uphold the principles and ensure that the mental health risks are recognized as workplace hazards. But ethically, I will go further, requiring global companies such as Meta to maintain the same mental health and labor standards across all countries where they operate. Because at the end of the day, moral responsibility doesn't end at a country's border. My resolution will combine enforcement with restoration, mandatory counseling programs, transparent contracts, and a fair compensation for trauma, and not just legal compliance, but moral accountability. So the principles that weighed most heavily for me are justice, fairness, and human dignity. Justice calls for redress, that those harmed should receive recognition and repair. In the case of, for example, Daniel Mutuang and the other Kenyan content moderators, fairness should also ensure equality, where no worker should be exploited because of geography or poverty. Human dignity should also remind us that every person, no matter how invisible their role, deserves safety and respect. Efficiency, while important, cannot override compassion. In this case, the rush for efficiency, for faster content moderation and cheaper labor by Meta led to human suffering. My moral compass tells me that the progress without compassion is regression in disguise. So this case has profoundly shaped how I see my future, whether as a policy maker or an investigator in an AI-driven world, where the technology will continue to grow faster than the laws that govern it. But as future professionals, our responsibility is to ensure ethics keep up the pace with innovation. As someone who believes in justice, I feel I can say called to be a bridge between the progress and morality, between what can be done and what should be done. My role will be to push for policies that place people at the center of technology by ensuring psychologically safe, safe environment in where AI is involved, and where transparency and accountability is promoted in the automation. And we should also keep on reminding the decision makers that data and algorithms serve people and not the other way around. The ultimate goal is an AI driven society that reflects not only intelligence but compassion. So, in conclusion, this case just reminded me that justice is not just a legal term; it's more of a moral calling. As technology advances, our responsibility to defend human dignity becomes even greater. My Christian upbringing taught me that leadership means stewardship, and stewardship means protecting others, especially those who labor and whose labor and pain may remain unseen. So my reflection ends where it began, with the belief that the true measure of progress is not in how fast we innovate, but in how faithfully we take care of the people behind the screens. Thank you.